Hello and welcome to today's guest lecture of the CIL eAcademy. We're in the first week dealing with international lawmaking. We had a very good start of the week yesterday and the day before yesterday. And today it's with great pleasure that both Nilofer Oral and myself as co-directors of the CIL eAcademy welcome Ambassador Rena from Singapore, who in her very busy schedule has accepted after a lot of convincing, we were just discussing that, to come and speak to you. And I think it's really, I was asking Ambassador Rena if she had a title for the lecture, and she said, no, I'm just going to speak to the participants about my experience as in international lawmaking and how it happens in practice and the experience as a practitioner. And that's precisely why we have invited you, Rena. And thank you so much again on behalf of Nilofer, myself, and the Academy and the participants for having taken time from your very busy schedule to be with us today. Just very briefly, before I give the floor to Ambassador Lee, to tell you a bit about Ambassador Rena Lee. She's currently Chief Executive of the Intellectual Property Office of Singapore, and she's also Singapore's Ambassador for Oceans and Law of the Sea issues and the Special Envoy of the Minister of Foreign Affairs. In this capacity, and I think it's about this, she'll be talking to you as an example for sure. She's serving as president of the Intergovernmental Conference of an international legally binding instrument under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of biological diversity of areas beyond national jurisdiction. The longest title for an intergovernmental conference and for a treaty. And that's why everybody says the BBNJ negotiation process. And she will tell you about it for sure. Ambassador Lee was also a member of the Legal and Technical Commission of the International Seabed Authorities, and many other things she's done throughout her career. She had also been posted as Minister Counselor at the Hague Diplomatic Office of Singapore between 2018 and 2020. I'm not going to tell you more about the CV and the experience of Ambassador Lee. I think this is enough to explain why we've invited Rena today to be with you and to share her experiences as an international negotiator and as somebody who's deeply involved in international lawmaking. And so again, with great pleasure, we're welcoming you, Rena, to the Academy. I'm convinced, absolutely convinced, that the participants will thoroughly enjoy your remarks and then also the possibility of interacting with you after. So the floor is yours, Rena, please.
Well, thank you very much, Patricia, and good afternoon to everyone. And for those who are in different parts of the world, good morning and good evening. My name is just Rena, so please feel free to call me Rena from Singapore. And after that very kind introduction from Patricia, I guess I don't want to add more. It is true that Patricia and Nilofer took a long time to persuade me to do this because I wasn't entirely sure that I was qualified to share this, to do this lecture, but I've decided to approach it from the perspective of a practitioner involved in international lawmaking. Obviously, it's not from an academic perspective. I'm afraid you'll have to turn to Nilofer and Patricia for that, but from a more practitioner's point of view, my experience with international lawmaking. I think but of course to thank the Center for International Law and the directors of the CIL eAcademy for inviting me to join you in this program. I'll probably speak for about the first 15 to 20 minutes, and then I really welcome all your questions that you may have. As I said, I wanted to share with you my experience in the development of draft texts in 3 different processes that I have been involved in, because I think they reflect and demonstrate the myriad different ways in which international lawmaking can happen. And that's one of the differences with domestic or municipal law. In domestic or municipal law systems, there's usually a set process for how the law is developed. And while there may be consultation processes, frequently who may end up as the subjects of those laws may not themselves, in many cases, be directly involved in the development of that law. This is in contrast, I think, with international lawmaking, where, in fact, frequently the subjects of the international law actually then do become involved in the making of the law. And the 3 processes that I wanted to share with you is first of all the Paris Agreement on climate change. Secondly, the work that's currently being undertaken in the International Seabed Authority on the development of the exploitation regulations for deep seabed mining. And then thirdly, and because Nilofer and Patricia will not forgive me if I don't mention this, the process in the BBNJ Intergovernmental Conference. So starting first with the Paris Agreement, and in the Paris Agreement, and in the year leading up to the adoption of the Paris Agreement, the member states, the delegations that participated in the negotiation process were always very clear that the development of the agreement on climate change, that new agreement that we were working on, has to be a member state driven process. And although there were 2 co-chairs, they were quite clear. Member states were quite clear that that the process belonged to them, and that they should be the ones developing the draft text. And so there were calls for proposals, and these proposals were all compiled together in what became known as the Geneva text. It was a huge document. There were many different proposals set out, and it took quite a while for us to work our way through that document. So what happened after the Geneva text was developed, what we call the Christmas tree approach, where everybody was hanging all their wish list on the text. We then underwent, we allowed, as by we, I mean the member states, then allowed the Secretariat to undertake what was known as a clustering exercise. And by the clustering exercise, what we meant was that proposals that related to the same issue would be placed together so that delegations could read and could understand what were the range of proposals in relation to a particular issue. And with that development of the clustered text, delegations then went into negotiations, and the negotiations were split into the different work streams. Because it was a fairly complex document, there were issues on mitigation, on adaptation, on transparency, on implementation and compliance. And all these were split into different work streams where different members of each delegation would go and negotiate. And all these work streams were open to all delegations to participate in. And as the deadline got closer and closer to Paris, at that time, of course, the president of that process was France. They listened, they paid attention to the negotiations, and there was a high-level segment where ministers were also involved in negotiating the text. And then the French presidency developed a text that was that was that took into account the views across the different parties and reflected what they felt was the landing zone. And this text was examined by all delegations and eventually, as you all know, adopted by consensus by the delegations during COP21. And it became known as the Paris Agreement on Climate Change, which I suspect goes down on record as one of the fastest agreements to reach the threshold for entry into force, because it was actually a relatively high threshold, double threshold of 55 parties representing 55% of total greenhouse gas emissions. But despite that high threshold, the Paris Agreement entered into force within a year. So it was a very member state driven process. The member states were in control of that process. They worked on the text before it eventually became developed by the French presidency. So that's one example, the Paris Agreement. The second example is in relation to the International Seabed Authority. The International Seabed Authority, for those who may not be so familiar with it, is the body responsible for the management of the area, the deep seabed, beyond the outer limits of the continental shelf. And currently, the organization is in the process of developing regulations for the exploitation of deep seabed mineral resources. Leaving aside the questions of whether we should be or should not be proceeding with the deep seabed mining. This draft of the regulations, which also can be accessed on the website of the ISA, was developed in a really quite different way from the Paris Agreement, because there was a draft text that was made available, developed together with the help of the consultant. And then it was put before the Legal and Technical Commission, which was a body of 30 legal and technical experts, not just lawyers, but also geologists, economists, environmentalists. And together, this Legal and Technical Commission worked its way through the draft text. I think we took maybe about 2 years of meetings to work through the draft text of the exploitation regulations. Now, in the course of working through the draft text, and this is what I think is an interesting feature of how the exploitation regulations have been developed, is that the ISA put out the work in progress for stakeholder consultations. And anyone who considered themselves stakeholders could weigh in on the development of the regulations. And if you go to the ISA website and you look at the stakeholder consultations, it's not just member states that weighed in on the draft regulations. You also had civil society, you had like scientists, you even had individuals who maybe were scientists or lawyers who chose to weigh in on the regulations as well. And the comments by stakeholders were then taken on board by the Legal and Technical Commission in further developing the text. So in fact, there was a much wider group of stakeholders that could participate in this lawmaking and to share their views on how they felt the regulations would develop. The Legal and Technical Commission finished its review of the draft regulations and then submitted it to the Council of the International Seabed Authority. And the Council is comprised of 37 member states, and the Council is currently actually negotiating the text of the exploitation regulations. So unlike the development of the Paris Agreement, where all the member countries, and by which I mean member countries to the UNCCC, which is the United Nations Framework Convention on Climate Change, could participate in the negotiations. Currently, the exploitation regulations are being considered by the Council of the ISA, which is about 37 member states. Obviously, those member states that are not members of the Council may join as observers, but not quite the same thing, I think. And when the negotiations are concluded, they will be adopted, even though it's developed by the Council. When the negotiations are concluded, the exploitation regulations will be adopted by the Assembly of the ISA, which comprises all members of the ISA. So we see a different process developing in the ISA relative or in contrast to the Paris Agreement. And then we come to the third example, which is the BBNJ agreement, of which I have the privilege to be the president. Again, unlike the Paris Agreement and unlike the ISA, in terms of the development of the draft text, actually, I've been very honored that the member states who are participating in the conference, and here these are the member states of the United Nations, and of course parties to, and those who are parties to UNCLOS, they actually from very early on gave me the pen to develop the text, as well as subsequent iterations of the text. And in developing the text, where I worked very closely with the Secretariat, I made an open call for proposals, waded my way through the many pages of proposals, and tried to produce a text through the different iterations. I think we're into the fourth iteration now, which not only potentially reflected, initially I think the text reflected a range of options. But as I moved into the fifth session, which just happened in August, I wanted the text to reflect more where I felt the landing zones could be. So you see very few options in the text. And my considerations were really to reflect the state of negotiations and the development of the negotiations, but also to develop a text that would actually be helpful in the negotiations. So while there were still many options on the table, these were not reflected in the text because they don't, when what I was trying to do was to drive delegations to engage on a single text. When you have many options, let's say if you have 5 options, it's very easy for delegations to go into the negotiations and say, well, I support option 1, or I support option 3, or I support option 4. And then they don't engage because they're really devoted to their own option. But when everyone has to engage on a single option, that's when they start working together and say, right, using this as a basis, how are we going to develop a text that finds consensus? And I think with this method, in the fifth session, we managed to make progress on the text, and there were consensus outcomes for quite a number of provisions. So you no longer see me working on the text because the member states themselves have been working on the text, and I neither sought nor was I given any mandate to further develop the text, because now it's really a member state driven text, because it shows the negotiations and the progress made by member states. And eventually we've made much progress, but we're not entirely there yet. So it will require another session for us to conclude. But when it's concluded, it will be adopted by the conference. And so those are the 3, I thought that these are 3 examples of 3 different ways to reflect how a draft text for negotiations may be developed. And quite obviously, if you look at other different forums, they will have different ways of doing it. Some will have a drafting committee. I've known of other forums where there have been working groups which have developed the text. But I think a key point and a commonality that runs through all three examples is that at the end of the day, the member states, the member states all participate in the lawmaking. And I think that is the important point maybe to note, which is that member states can participate actively in the development and the eventual finalization of the text, whether it was the Paris Agreement, whether it is the exploitation regulations or the BBNJ draft text. At the end of the day, they will be negotiated by all the member states, and they will be adopted by all the member states. And I think that is what sets international making of international law apart from national law. That however we come to that process, whether it's one person developing the text or a small group developing the text or everyone developing the text, at the end of the day, member states will have that opportunity to comment on the text, to work on the text, and then to be able to eventually adopt the text, whether by consensus or by voting. That text is adopted by the body, and that's what's important, because international law, actually the states have the sovereign right to decide whether or not to be part of a particular treaty or an agreement. And because of that, unlike domestic law, because of that, I think it's very important that states have a voice in the development of that agreement. And that's what I think, however different the processes are organized, that's what international lawmaking strives to do. And so I see from my stopwatch that I've already gone to 18 minutes. So I think this maybe is a good point at which I can stop and then invite questions, and I'd be happy to amplify on any of the points that I've made earlier. Thank you.
Thank you so much, Rena, for sharing your experiences and in particular with regard to three processes that you've been deeply involved as a delegate, but also now with regard to the BBNJ as chair of a process, which is certainly a different exercise also in trying to bring the states together. So I'm going to open the floor for questions. We're very happy that you're available and willing to interact with our participants. Perhaps while they're thinking to break the ice, maybe I can ask you an initial question that has to do with what you said and linking it to the lectures we've had on a more broad framework on international lawmaking, which happened to be delivered by me yesterday and the day before. And so we were already discussing these issues on a more broad aspect, and it's good now to focus with particular examples. But one of the, the issue that you pointed to, that in international lawmaking is basically an exercise of self-regulation. And I think that's very different than when we look at the processes that exist at the domestic level, where the legislator is not necessarily the final destinatory of the norm. So certainly the process of self-regulation has its own specificities, and maybe you can develop that a bit further. But one point that came up in the discussions that we had in the Academy yesterday and the day before, and especially, of course, I was sharing my experience as a member of the International Law Commission, and we were speaking about the interaction with the Sixth Committee and discussing how sometimes the fact that there's limited participation among the UN membership in those interactions. So only on a regular basis, only 40, 50 states interact in an active way in the process of discussing the work of the Commission and taking it forward. And so we were discussing about this lack of inclusivity in international lawmaking, and the fact that the process is driven by a limited number of states, sometimes because of issues of human resources and capacity. And so maybe you could explore a bit in these three processes that you've participated, whether you've seen that the process is more inclusive in terms of the representativeness of the states participating, and also what can be done also to increase global participation in such important negotiations. And so I'll leave that as an icebreaker while our dear participants think of more questions. So maybe you can answer this one, and then we can move to the participants, and we already have one in the chat and then one raised hands.
Okay.
Please, Rena.
Well, I mean, thank you very much. Thank you very much for that question. Actually, there are many ways in which to approach the question that you have asked, Patricia, but maybe I'll answer the question directly in terms of inclusivity and participation. I think that it's true that there are a number of states for whom resources are a little bit more limited, and therefore cannot participate, I guess, as fully as they would like to, or as they are able to. But in many of the processes that I've been involved in, including more than just the three that I have named, actually states are very good at organizing themselves. Certainly you see that for all three processes, and by pooling together resources, that's how they ensure that their voices are being heard. So working my way backwards, for example, within the UN system, I'm sure many people are very familiar with the regional groups. And a number of states actually participate on this basis, that they're represented by their regional groups. So for example, in BBNJ, we have the G77 in China, which represent around 134 states. Then there are the regional groups like the African group and the Pacific Small Island Developing States, CARICOM, the European Union. So they all pool their resources and they speak as one group. And that kind of ensures that if you're smaller, less well-resourced, by being part of the group, you can ensure that your voice is being heard. Now, obviously, within the groups, there are also these, I guess, negotiations to make sure that your interests are represented within the group as well. But these regional groups are also present, for example, in the ISA negotiations, in the climate change negotiations. But we've seen in other processes as well that sometimes the groups are not organized along regional lines, but they may be organized along interests. So, for example, if you look at UNCLOS, we know that there were a number of, shall I say, interest groups that came together and negotiated as a bloc. Examples being the archipelagic states, the geographically disadvantaged states, the landlocked states. They came together because they had that common interest defined by their geography, and then they negotiated as a bloc. And I think that these are ways in which states may participate may participate even if they may not be present at the meetings. And you mentioned, Patricia, the interaction between the ILC and the sixth committee. It's true that maybe you get about 40, 50 active participants. But for example, one of the groups in the sixth committee that I'm aware of is the non-aligned movement, that the non-aligned movement does to some extent coordinate in the sixth committee. And that represents another way for delegations who may not have the bandwidth to attend every single meeting to ensure that their views are being heard. There's also another way, and I think the stakeholder consultation by the ISA, for example, is one way in which inclusivity can also be ensured by opening the consultations to all. And I think that's what's interesting about the ISA stakeholder consultation, because the contractors, the member states, the civil society, individuals could all participate in commenting on the draft regulations. Likewise with the BBNJ process, although maybe to a more limited fashion, proposals were not limited to member states. Civil society observers generally could participate in providing proposals as well, and certainly joint proposals were always welcome. So there are also these ways of being able to contribute, and civil society, I have to say, is very active in the BBNJ process, while not maybe in directly negotiating the agreement, but in terms of working with member states and developing, organizing sessions to keep member states updated and to educate member states on the different issues. I think they've also played an active role, and these sort of indirect ways are also ways in which not just member states, but increasingly, I think, while traditional international law is about states as the actors in traditional international law, I think over time we're seeing kind of this development of other stakeholders and the role that they play in international law. And these kinds of consultations actually enable participation from these stakeholders as well. So, yeah.
Thank you. Thank you. I think that point also, that was the other question I had, but now I see that we have 3 hands, so I don't need to add more. But I mean, the issue of civil society participation when we look at the climate change negotiations, well, not just the Paris Agreement, but also now the COPs and certainly the BBNJ, and we saw that also with regard to the International Criminal Court, for example. And civil society has really been playing a role, not only, I think, in trying to get their points across, but also in helping states. I think you have a very good point in that civil society participation by doing in a lot of the detailed work, more technical work, position papers, also contributes to helping smaller states keeping up with the negotiations and seeing also their interests, because sometimes it's not very clear for some states, what their interest should be in the negotiation, and so that that clarification and enlightening process also certainly helps with that. So I'm going now then to move to our participants. We have at least 3 hands. I'm going to maybe, Rena, if you agree, I'll take 3 questions. We'll take 3 questions and then we'll see where we go next. So first we have Jatu from Indonesia, then followed by Daniel from Kazakhstan. So Jatu, please.
Thank you, Professor. I would like to ask the questions to Ambassador Lee. Hi, I've been lucky enough to following the issue with the BBNJ, and the last ICJ, I got the opportunity to follow some of the discussion, and we really appreciate your leadership, the presidency in the BBNJ. My question is basically regarding the nature of the negotiation itself, because in BBNJ, the negotiation is heavily based on the text draft that are being proposed by region groups and also some countries. And there's also the issue with the political urgency that it has to be concluded as soon as possible. And that's why it's usually when we are talking about the text-based negotiation, it could lead into a big difference, or many proposal comes from many sides that probably hard to decide, because if I'm not mistaken, so far basically a text would not be concluded unless everyone is agreed to it. So how do you see how to balance the quality of the treaties or agreement that are being made if we are talking about the political urgency that it has to be finished, while on the other hand, the negotiation itself could come into a big contentious issue between countries or sides that consider that their sovereign rights might be disturbed by the drafting of the text. Thank you.
Thank you so much, Jatu. So we'll take the question from Daniel from Kazakhstan.
So my question is quite general. So what if states, what if there is a conflict of interest in states? So different states want different provisions to be input into certain treaties. How do the drafting team resolve such disputes, or at least try to help in the negotiating process? Thank you.
Thank you, Daniel. The third question, Dilnasov from Ethiopia, please.
Okay, thank you very much, Professor Rena, for Ambassador Rena, for the wonderful presentation and very insightful. My question is related to the climate financing, about the Paris Agreement. So I think countries are failed to just fail to give their commitments in relation to their financing commitments. So what is the main problem? Is it related to its Paris Agreement, the law itself, to make it contextual with this course? Is it related to its nature of the law itself? It has binding character, or its effectiveness. So some of the professionals argue that this agreement is failed by itself. So that how do you just suggest in this area? Because there are vulnerable countries because they are not emitting much, but they are affected by this climate change, especially from developed countries. And most of the countries, the giant countries, are not contributing their commitments. So what are the main, how can be this issue solved? Because the emission of the targets to be diminished, or the target of the Paris Agreement would not fail. Should we need another framework to solve those kinds of issues? Thank you very much.
Thank you very much. So, Rena, now over to you for whatever responses you may want to give to some of the most straightforward and some of the most difficult questions.
Well,
go ahead.
thank you. Thank you very much, Patricia. I think to some extent, the question by Jatu and Danielle are actually quite related. So I'm going to take both together, starting with the observation that in the BBNJ process, we're engaging in text-based negotiations. That is true. I mean, ultimately, in order for us to be able to agree on a treaty, we have to engage in text-based negotiations. But in fact, the genesis, if you look at the genesis and the development of the BBNJ process, actually it's taken us about 18 years to get to this point, beginning first with an ad hoc working group and then a preparatory committee before we began the intergovernmental process. And during the ad hoc working group and even the preparatory committee, and even in fact the first session and the second session of the IGC, we didn't engage in text-based negotiations. We spoke about the issues, we negotiated the issues more broadly. But it's a question of, even if we had agreed to those issues, it's a question of how to translate those agreements into text itself. Then the question about balancing the multiple proposals, which is in a way similar to the question that Daniel had asked about. How do you resolve conflict between states where there a conflict of interest between states where state A wants option 1 and state B wants option 2? I think that's the very essence of negotiations, that we work together to identify what are our common interests, what are our objectives, and then we find the language to be able to express our common agreement. And you multiply that by all the countries in the process. So it's a complex undertaking. But as the history of international lawmaking shows, it's not impossible for us to reach agreement. Now, in terms of the balance between shall we say, the quality of the agreement from a legal point of view, and the political compromises. I think in any treaty, there's always an element of political compromise. And of course, in treaty drafting, we always engage in what is termed creative ambiguity, choosing words that sometimes are not. No, if I were a drafter of a domestic legislation, I would have taken a different approach. But because this is the treaty is aimed at trying to forge consensus amongst different interests, I think that is where then having the ability to be creative in terms of how we draft becomes important. Now, obviously, then this is what allows law courses to take place, right? Where you can ask questions and have the students write exam answers on what's wrong with this treaty and what's wrong with the language and how do you interpret that, and they form the basis of work for all the international tribunals as well, as states disagree on the meaning of those treaties and then go to the tribunals and ask them to resolve it. I think it's a balance, and the states that are involved in the negotiations have to figure out the balance of political interests with the I guess legal robustness, if that's if we want to put it that way. Now, in terms of the question on climate financing, this is not a work stream that I followed, so I don't want to hazard a guess as to why countries are not living up to their commitments in relation to climate financing. Unfortunately, this is not really an area I'm familiar with. As you know, the Paris Agreement does have an implementation and compliance function. And that implementation and compliance function is intended to be facilitative, non-adversarial, non-judicial, non-punitive. And it may be that the facilitative nature of the implementation and compliance might be one way in which it can help identify how it can help to facilitate states from how it can help to facilitate states in their implementation of the Paris Agreement. It's of course one thing to say that you will comply with an international law. It's another thing to actually implement it. And I think this is one of the features in the BBNJ agreement as well. The recognition that capacity building will be very important in driving implementation of the obligation. Sometimes it's not that states don't want to do it, maybe they lack resources to do it, and that might be something that needs looking at. But you know, I'm going to stop there because I don't feel qualified to answer a question on climate financing. I'm sorry.
Thanks, Rena. I would think that you know, it's the right approach, but we will have later on in the Academy a module on climate change law, and you might save, then also you may save that question again, which is an important question, but of course it has to be also asked in the right setting. And it's something, of course, that we all follow carefully and are concerned about, and perhaps we can come back to that point when we address climate change law. So let me see if we have something in the chat or some more requests for the floor. Ozge, please.
Hello, Professor. Thank you so much, Ambassador. I wanted to ask a small question. You have mentioned the International Seabed Authority process about including the different stakeholder participation during the regulation and draft text making. This looks like a great idea, but doesn't that prolong the process a lot, or doesn't it maybe sometimes block the process? Because when you open it to different stakeholders, different parts of the public might see that it's relevant to them, and it's a great opportunity to involve their problems or their concerns. But on the other way around, it can be an open question to everyone. So what's the limit, or how does the authority deal with this problem? Thank you so much.
Thank you, Ozge. We have one more question, so we'll take now a group of two. From Izul, from Brunei. Izul, please.
Hi, good afternoon, Ambassador. Thank you for a very insightful presentation earlier. And my question has more to do with your role in steering the BBNJ negotiations and, you know, framing the process as it may. And can you please share with us what you think how you individually have been able to successfully run the process through, and you know, what hurdles you you came across in like the 18 years or whatnot of the whole process, if you were there from the start, but then also the role of, you know, having been involved in 3 processes, obviously in different capacities. How do you feel, you know, having been involved in being very hands-on with the BBNJ, how have you been able to use your past experiences, you know, to better the process in the final framework where you had a bigger role, as it may? Yeah. Thank you.
Thank you. Thank you so much, Ozge and Izul, for those questions. Maybe we'll turn to Rena now for an answer on those two.
Well, thank you very much. Maybe first I will I'll take Ozge's question first on stakeholder participation. My own sense is that actually increasingly, unlike maybe, I don't know, in the 40s or 50s, of course I wasn't around then, but maybe in the 40s and 50s, international law was maybe a really arcane arcane subject limited to diplomats and international lawyers, and maybe not many people took an interest in the development of international law. But today, I think we operate in a very different world, where there are many people who are very invested in how the world as a whole works, and the kinds of systems, the kinds of processes that we are putting in place in order to manage the world. I mean, I think the reason why I chose these three processes, of course, I have been involved in other processes, but the reason why I chose these three processes is, in a sense, these three processes cover, I guess you could call them the global commons, or they are issues that affect all of us. Climate change, the area which is not subject to the sovereignty of any state, the areas beyond national jurisdiction, the high seas and the deep seabed, which again are not subject to the sovereignty of any state, where all of us, states and citizens in the states, have a stake in how they're being managed, and how the resources are being utilized. And so, you know, I don't see the stakeholder participation as prolonging or blocking the process. I think if we look at the experience of the ISA, actually most people hewed, or they kept to the timelines. I think I cannot recall specifically, but generally everyone was given like 40 days, 30 days or 40 days to comment. And most of those who participate in the stakeholder consultations actually kept to those timelines, and so it didn't unduly prolong the process. And I think that's important because, as I said, we had comments from states, from contractors, from civil society. They bring to the table different perspectives. And I like to think that they improve the quality of the text when we take on board the different comments, because no one is capable of knowing everything. But by bringing together all these different perspectives, it can give people pause and they can go, oh, right, I didn't think of that. Now, how shall we incorporate this into the text? And I think that helps in developing the quality of the agreements that we are working on. And then moving on to Izu's question, and I should have said this at the beginning, everything I say here today is my personal view based on my personal experience, so they're not intended to reflect the views of the government of Singapore. What I set out to do when I was elected as the president of the BBNJ IGC, and incidentally, I was elected in 2018. So yes, I participated in the ad hoc working group, not as far back as 2004, but I think I started in 2012 or 2013. And yes, I participated in the preparatory commission, but I'm certainly not as experienced as those who have been there since the beginning. But when I was elected as president, I think one of the things that I wanted to do was for the process to be really smooth. I think we've all been, for those of you who have participated in international negotiations, there have been certain processes that haven't proceeded as smoothly, where there have been many interruptions, many process or procedural challenges. So what I set out to do was to try and build a process that was seamless, that was smooth, in order to enable delegations to really focus on the substance and not worry about the procedures and the processes. And I think I did that through a combination of reviewing how other processes operate, picking bits and pieces of what work and putting them together, undertaking a lot of consultations with delegations, and preparing and giving delegations sufficient time to prepare, like telling them, okay, next week when we meet, this is what we're going to do, this is how we're going to do, how we're going to carry out the meeting, so that delegations know what to expect. and they're not blindsided. And then of course continuing with the process of consultations. For me, I think it's important, again, because we're dealing with the global commons, and we're talking about the areas beyond national jurisdiction. These are areas that belong to nobody, but they belong to everybody. And therefore, it's important that we all learn to work together towards that common objective. And I guess I see the BBNJ process as being that precursor, or giving us, as all different states with all different interests, that confidence to know that actually when we put our minds to it, we can all actually work together. And that's what I have, what is the past tense of striven to do in the process. Obviously, I cannot comment. You will have to ask the delegations involved in the process to know whether it has or hasn't worked. Yeah, that's what I try to do.
Thank you so much, Rena, for your answers, but also for this important and inspiring remarks. I think they are even more important in the moment we're living in. And on that note, Nelly from Armenia wrote in the chat, Your Excellency, thank you for your interesting lecture. Unfortunately, nowadays the world faces terrible times of wars, aggression, violations, and there's no political compromise. It's kind of a big diplomatic crisis epoch. I'm reading from the chat from Nelly, and it's true. I think we are in a difficult moment. We spoke yesterday and the day before yesterday how there is this kind of an impasse in treaty making. States don't seem to be interested, or there's a fatigue, or there are political difficulties, and the atmosphere is really not the best one at the moment. So the BBNJ, I think it's really an important moment where under your very able leadership, states are coming together, and hopefully in one last session they will come together and overcome those differences and those political difficulties in a smooth process that you are ensuring, and we'll be able to have a treaty which not only, I think it will be very important because it can show that the international community can still come together in difficult times, but also to regulate, as you mentioned, a common area that is of common interest to all the humanities. So I think on this note, we're 2 minutes to the end. On this note, we can end our guest lecture today. And again, Rena, thank you so much for having shared with us your insights, your personal experience, your tips, and also thank you so much for the leadership that you've done, that we had in this processes, and especially in the BBNJ. And we do wish you all the best, hopefully for the last round to happen as soon as possible. And Singapore, and I think all of us at CIL and in the rest of the world, we're very proud of you, and we're very proud to have had you in our academy, and our participants will certainly give you a virtual round of applause. Thank you so much for being with us, Rena, and I'm seeing a lot of nice comments coming up in the chat, so I'm sure that we've all deeply appreciated you taking the time to be with us.
Well, thank you very much to Patricia. First of all, of course, thanks to all the participants for your attention. I really appreciate your attention, your questions, which are thought-provoking. And obviously, if we had more time, we could go into a lot more detail. But I hope I've shared with you what is, well, again, as I say, they're my personal experiences. And I think, that I guess at the end of the day, having international lawmaking is an exercise in all different states coming together and working together. And it's true, in these times, we really need to emphasize the importance of all of us working together, and being willing to listen to one another and learning from one another, and being committed to working together to solve the world's problems, because we do have big problems to solve: biodiversity loss, climate change, plastic pollution, and that can be done if we put our minds and our wills to it. So thank you very much to CIL for having me, and thank you to everyone for your attention. Thank you very much.
Thank you again, dear Rena. We hope to see you again soon, perhaps for another talk on how you ended the BBNJ negotiations. We'll keep that invitation open. And to our dear participants, thank you so much for your active participation throughout the week and today. And we'll see you next week for our module on international peace and security, where we'll have Professor Dirit Ladi and Professor Dapo Akande with us. So it's going to be another exciting week. Thank you so much. Take care and see you soon. Bye-bye.
Bye-bye.